practicing law for 35 years. I hate to admit, and in the last 4 or 5 years, my primary practice has been cottage succession planning, and I have clients really all over the country, including people with property in Canada. And cottage succession planning has become a very, uh, a popular topic, I would say, and a big concern for many people. And I think that primarily, like anything else, with the kind of the baby boomer generation, trying to look at uh, cottages are often a primary asset in the estate, and it has a special uh, sentiment and emotional attachment to most of my clients, and therefore they looking to see what they can do about planning for the cottage, and in particular keeping it in the family. So tonight I'll discuss various issues and various considerations that you might want to think about with respect to your properties, your cottages, and planning for those, and with the intent, hopefully that'll you and generations to come will enjoy the cottage and your property. So with that, I'll get going here. All right, sorry about that. Getting a little delay, it looks like. The topics I'm going to cover today: uh, Michigan real estate taxes. As many of you know, if you're owning Michigan property, real estate taxes have become a significant issue since basically 1994. I'll get into that a little bit. Cottage planning issues, cottage participants' goals, real estate principles, and some solutions you might want to consider. So Michigan is a unique state. Michigan and California are the only two cottages that have a difference in uh, the property from a taxable value and the assessed value. So here, let me annual property assessments increase. The increase of annual property assessments for tax purposes is capped and cannot exceed the lesser of 5% of the rate of inflation during the preceding year. However, when ownership of the property is transferred to a new owner, the property value is uncapped for purposes of calculating property taxes, and the value is adjusted to the current fair market value or the assessed value. So this came into play in 1994 when Proposal A was passed. Sorry, I'm having some technical difficulties here. Just a second. So under the Michigan property tax system, the property taxes remain capped until there is a what they call transfer of ownership. And the statute specifically provides what constitutes a transfer of ownership. Uh, Throw out everything you ever knew about the verb transfer and the noun ownership. Some events that are transfers are not transfers of ownership under our current uncapping statute, and some events that are not transfers at all are transfers of ownership, again under the uncapping statute. So transfers of ownership include, but are not limited to the following, unless a new owner is a qualified family member: conveyance by deed or land contract, conveyances to a trust, conveyances by distribution from a trust, inheritance from a will or a trust, a change of present beneficiary of a trust, and transfers of ownership, interest in a limited liability company, corporation, or other legal entity when, on a cumulative basis, more than 50% of the ownership has changed, even where the new owner is a qualified member. And we'll get into that a little bit about planning and the entity of choice for planning. Transfers of ownership do not include transfers to a spouse or jointly with a spouse, transfers to a qualified family member, transfers subject to a life lease retained by the grantor when the lease terminates if the grantee is a qualified family member. I'll talk a little bit about that. And transfers to a trust if the settler's spouse, or a qualified family member is the present beneficiary of the trust. So qualified family members include the following, and this is significant as you look at transferring your cottage to other individuals within the family. The transferor, the spouse of the transferor, the transferors or the transferor's spouse's mother or father, brother or sister, son or daughter, including adopted children and grandson or granddaughter. Note that this definition does include in-laws. So that may have some significance as you look to how you transfer your properties. Cottage planning issues. So what should you look about or think about? What are some of the issues you should consider as you may want to plan for your cottage? So oftentimes there may be a dilemma with regard to the cottage planning. Do participants, people in the family, view the cottage as an asset of considerable economic value or a retreat for family enjoyment to be preserved for future generations? And the feeling or how people view the cottage oftentimes differs, maybe depending on generation and who's looking at it, obviously, and who's considering that. What is a cottage plan? A cottage plan is an agreement that describes how a cottage will be shared, managed, and passed on to future generations of family members. What does a typical plan deal with? What kind of issues are dealt with within a typical cottage succession plan? Who should own it? Who should manage it? How are costs allocated? Who should pay for the expenses associated with your cottage? What if an owner wants or needs out? How do you handle that? And what's that look like? Who gets to use the cottage? And with regard to use, how should use be scheduled? I'll kind of briefly discuss the cottage language that we incorporate in our plans and this will help you as we kind of talk about planning. So typically the initial generation are considered founders. So here we have Tom Parker and Mary Parker are the founders. They're kind of like the initial owners, the original owners. Then if you go down a generation, you have, in this particular case, 3 children. And oftentimes we'll talk about branches or the branch within our planning, we kind of plan and maybe allocate expenses and usage based on branches. So if you look at this diagram here, the next generation, Andy Parker, and his descendants will be part of Andy's branch. Bob Parker would be Bob's branch, and then Carol Smith, who is a child, and you look at her descendants, it'll be Carol's branch. So, what are the normal goals of participants or people that I work with, my clients in cottage planning? The founder's goals are almost without exception to keep the cottage in the family for generations so that it can serve as a gathering place for extended family. That is oftentimes my clients, the view they have and why they're coming to me to do some planning, because their primary interest is to keep the cottage in the family. Potentially to give children equal shares of the cottage. So as you pass the cottage down to your children and then subsequent generations, to keep it equal, again, within the branch concept, equal among the children and then down generations from there. Keep interest in the cottage out of the hands of in-laws and creditors, and reinforce the family interest over potentially any one heir or one individual's interest. The big purpose in developing a cottage succession plan is to keep the property in the family and reinforce again and to emphasize the interest of the family as a whole as opposed to a particular individual within family generations. So typically, what's the goal of heirs? So maybe not the founders, but subsequent heirs. Protect cottage from a divorce, develop a decision-making structure and control mechanisms within the cottage plan, develop consequences for failure to abide by rules. And these rules that may be developed are financial rules, as well as how you use a cottage, how you treat the cottage. So behavioral type rules. Develop a fair and flexible scheduling system. Right now, the smaller the family, scheduling may not be an issue, but if you can imagine, as you go down maybe 1, 2, 3 generations, scheduling may become a bigger issue as you have more members and more participants and owners who will want to use the cottage. And potentially have the ability to sell the interest back to the family. So let's talk a little bit about real estate principles. So as you think about ownership of a cottage, there are various common law rules that apply if you don't change those or you don't develop a plan. And those common law rules are not typically what people either know or think about or understand. So it's important at least to have a basis of what might happen if you don't develop a plan. So typically, title of the cottage is held normally by the founders. If a husband and wife, they hold it as joint tenants with rights of survivorship. So with that kind of ownership, called a joint ownership, one potential type of joint ownership, title of the property automatically passes to the survivor on the death of the first co-owner, regardless of any provision in a will or trust. So typically, if it's joint tenants with rights of survivorship, it doesn't matter what you put in your will, what you put in your trust, the property by law transfers to the survivor. So heirs, how do heirs typically get the cottage? Most children and potentially cousins. So if you own it jointly with brothers and sisters and maybe got it from your parents, they hold title to the cottage as tenants in common because they receive a share of a cottage. So again, if you're the founders and you pass it down to your children, they'll typically get it as an inheritance, as a gift, or as a distribution from a trust. And they'll own an undivided interest in the cottage, usually a percentage. So if you have 4 children, It'll go down to 4 children. They'll each own a 25% interest as tenants in common. So again, I kind of talked about what are the common rules that exist if you don't change that and you don't develop a plan. So each tenant in common has a right to partition. Each tenant in common may use the cottage at any time. And a tenant in common may transfer his or her interest to any person at any time, including his or her spouse. In addition, a tenant in common does not owe rent to the other owners for using the cottage. So there are no rules that operate when you have multiple people who own the property as tenants in common. So tenants in common could mean that trouble is coming. And I'll talk a little bit about what that might look like. So with regard to planning on tenants in common, so again, if you don't plan, remember the common law rules would apply to the joint ownership or co-ownership of the cottage. So there are various ways you can plan with regard to a cottage and various structures that could be used. One structure you might consider is a co-ownership agreement. And this may be beneficial for tenants in common if the cottage will be sold soon. We might just have a co-ownership agreement among that generation. One big issue with these co-ownership agreements is that only those people who sign the agreement are bound by its terms. So if the intent is to keep the cottage in generations to come, a co-ownership agreement oftentimes does not satisfy that intent. A better way to plan and to set up a structure or a planning mechanism to avoid this tenancy in common issues is to have title to the cottage held by a limited liability company or a trust. That way, the actual ownership is transferred into one of these two entities. With regard to a cottage plan, with respect to management, if the property is held by LLC, it's typically managed by a management committee. So it operates in a similar fashion to a board of directors. If it's in a trust, then usually co-trustees make up this management committee. In an LLC, it's typically they're called managers and the owners are called members. In a trust setting, the management committee is typically made up of the trustees and the owners are beneficiaries. They own a beneficial interest in the cottage. In either case, it is far better to have one representative from each branch of the family involved in decision making. So if you go back to the discussion of branches, oftentimes when I set up these plans, there'll be a representative from each branch. Again, it could get a little bit overwhelming if every owner is part of the decision making with regard to day-to-day things and everything else as the owners grow and as you move down generations and the ownership gets members get larger and larger. So with regard to the ownership of a beneficial interest, founders decide who may be an owner or beneficiary. Almost all cottage plans restrict participation to lineal descendants of the founders. So again, keeping it in the family and typically the blood, the blood relationship or what we call more legal term, lineal descendants. This is a key clause that keeps the cottage within the family. This clause prevents in-laws from becoming members or beneficiaries. So again, in the cottage plan, how does ownership and beneficial interest, I'll discuss kind of the transfers. Most cottage plans, and when you look at uh, a cottage plan, you may have somebody who, for whatever reason, either doesn't want to be involved or can't be involved. So I think it's important as you look at planning to have what I call a graceful exit. Remember, you're dealing with brothers and sisters or cousins, these are family members. So we often build in a mechanism where if people truly want out for various reasons, we give them a way to get out and do it in a what I call again a graceful or a more of a uh, friendly way to do it. And we call these either a put option or a call option. The put option requires the company to purchase the interest of a member who wants out. And the put option typically in the agreement itself, it'll provide uh, how the property is valued, and it'll also provide um, the terms of payment. The other option is a call option. This is usually a forced buyout of different what we term here difficult members, maybe members who are not necessarily difficult, but um, they can't afford to stay in, they can't afford to pay, so there may be delinquent payments, and the call option provides a mechanism to buy them out if they don't pay their fair share or things like that. And again, with regard to the call option, the agreement itself provides how it's valued and kind of the payment terms and those kind of things. Whenever you have a buyout, uh, the people who are remaining behind are typically, they're going to have to buy out the person who wants to leave. So normally, in developing a plan, most founders or the people who are developing the plan want it as least burdensome as possible for those who are staying behind. Because again, the idea is to keep the cottage, keep it in the family, maintain it in the family. So you might develop favorable terms to allow them to buy the exiting member or exiting beneficiary out. Uh, and again, more favorable to those who are staying and maintaining ownership. The cottage plan also deals with the finances and the cost of maintaining and holding on to the cottage. Expenses are typically allocated according to the members or the beneficiary's sharing ratio or their percentage ownership. Most cottage plans will require the preparation of an annual budget and an assessment against members or beneficiaries at the beginning of the year or the season. If you're fortunate enough, some founders or some people who set up these plans may be able to and have the financial wherewithal to provide an endowment. And that would be very fortunate if you can provide an endowment that can cover cost and expenses associated with a cottage. So, with regard to the finance piece, what if a co-owner or beneficiary cannot pay? What if they cannot pay? Oftentimes, a plan might include one or more of these kind of what I have termed here escalating sanctions. You could impose a late payment fee, could charge interest on the amount they can't pay. You could suspend a individual's use rights. You could suspend not only the individual who can't pay, but that individual's branch, the branch of that individual's use rights. You could suspend voting rights or management participation. So again, like I mentioned before, if someone can't pay, and oftentimes if it goes on for a long enough period of time, uh, it could trigger this call option, which would allow a forced buyout of the delinquent person. So again, part of the finances piece of a plan, uh, mentioned an endowment. Many clients will endow a cottage with a dedicated fund of money. So for example, if you're fortunate enough and can put $500,000 maybe in an endowment, I throw out a number, invested at 5%, this could create a pre-tax return of $25,000 a year. This sum is sufficient to operate many properties, many cottages. The endowment may be held and managed by a bank trustee or by the LLC. The endowment distributes to your descendants if the cottage is sold. So again, if you sell the cottage, since this endowment would have been an inheritance, then you may provide for in your plan that if it's ever sold, it still gets distributed among your descendants and heirs. One way you might consider in funding an endowment is a second to die life insurance. This is typically an inexpensive way to develop a fund that would occur on the death of the survivor of the founders or the husband and wife at the initial generation, and then it could fund the LLC or the trust to help to defer expenses and pay expenses. On my website, www.cottagelaw.com, I do have an Excel spreadsheet that you could go to and kind of fill in your numbers if you're interested, and kind of figure out what the cost would be and what you may need to do to develop, to put in to create this endowment that might cover expenses if there's an interest. Scheduling. A cottage succession plan typically will deal with scheduling. There's two different approaches. One is the rooming house approach, and obviously it's going to depend upon the size of your cottage, how many people, owners there are, so what's the usage look like. The rooming house kind of scheduling is a come one, come all, assuming you have sufficient space to kind of accommodate that. The more often or the more frequent scheduling system is kind of a time sharing system where you allocate specific use times, again, normally based on the percentage ownership or the sharing ratio. And oftentimes my plans might have a specific table. Here's an example where you have the choice, and you have, in this case, 3 branches, and you just alternate through the years on first choice, second choice, third choice. As many of you know, you live in or your cottage is in Michigan, so the and Michigan has a limited kind of season. Some people think of Memorial Day, although that might still be a little iffy, to Labor Day. It's kind of the summer or the prime cottage season. So it can be somewhat limited in Michigan. Here's another example where we have 6 branches here, and kind of how you could develop this sharing formula for scheduling of the cottage. So let me I'll briefly say that what I had talked about were developed for the LLC approach to property ownership and management. In Michigan, I will briefly talk about this uncapping provision. And with regard to Michigan, I'm using more trusts because under current law, as of 2015, the trust structure allows you to transfer beneficial interest in the trust down 2 generations with no uncapping event. In the LLC, the current law is that if you transfer over 50%, and these are cumulative transfers. So if the ownership is in one generation, you transfer it down to the next generation, an uncapping can occur at the second generation. And if you recall, remember there's the taxable value and the assessed value. And uncapping will occur. Uh, will re, will have the uncapping of the taxable value revalued at the assessed value. And with cottage property, and other than the kind of the depression of the downturn in 2008, 2009, 2010, uh, cottage property has now increased in value again pretty significantly. In a lot of cases, back up to the value it was at prior to that, to the recession, I should have said. So so again, trusts are more often used with regard to my Michigan clients than LLCs for that purpose. And if you want to talk further about that or discuss that, you can certainly feel free to contact me. So when do you create the Cottage LLC? And again, we'll talk about LLC here. Uh, it can be immediate, so that with the founders develop this plan, they can transfer the property in there immediately. And this immediate is important if the parents want to use exclusion gifts to minimize estate tax. So if an estate tax is an issue, then oftentimes you'll transfer the property to the LLC immediately. Uh, it's also necessary if the cottage is owned by siblings or cousins as tenants in common. Again, if there's a wide ownership, you typically would want to fund or transfer to the cottage immediately, or to the LLC immediately. You could also create the Cottage LLC upon the founder's death. That's what we call a springing LLC. And if you're going to do this, it should be integrated into the founder's estate plan. You typically would develop an operating agreement during life for the Cottage LLC, and you could attach that to the trust as an exhibit to basically say that the LLC will be operated under this operating agreement on the death of the founders. And it would typically provide that the LLC is not formed until the death of the second founder. On the springing LLC, it allows parents to retain control for lifetime, but establishes a plan so that the children may share the cottage in the future, and it provides the rules and procedures for that sharing. So kind of just to summarize what we talked about and what we, with regard to cottage planning, the LLC or the trust offers the best approach to cottage planning. And I always say that, you know, as unique as property can be to families, all families are also unique. So there's no single or right solution for every family. My agreements differ. I can't say I've drafted the same agreement for any of the families I've worked with, and so they all differ in various aspects. And so part of the process is to allow you to participate in the planning, and we talk about how that should look for you. Again, you don't need to strive for perfection, and don't expect miracles. But if you want to plan and you want to protect against a lot of issues that might exist with regard to cottage law planning, you know, with regard to cottages and, for example, like we talked about, ownership as tenants in common and the divided ownership, then you should plan. And if you don't plan, then there's a larger potential that negative things could happen. And don't plan for too many generations. As you think about it, each generation will get larger and larger. So keep it as simple as possible, but develop a plan. And a reasonable plan is better than no plan at all. For more information, if you haven't, you could consult the book Saving the Family Cottage. Many of my clients have read the book, and that's how they've reached out to me. Uh, so that provides a good guide and a good discussion of some of these issues and planning with regard to your cottages. Thank you for your time. I ask Eric's now to open things up for questions. If any of you have questions, or I can answer anything about planning or anything, any particular issue you might have or concern that you might have.
Thank you, Mark. Yeah, as he as he just said, if you want to utilize the chat function, you can type out your message, and I will relay those questions to Mark. If you don't have any right now, or have a follow-up, his information is right there to phone or email him. As a reminder, this presentation was recorded, and if you needed to leave, I will send a follow-up email with the full link to the webinar. All right, Mark, we have a question. How helpful is a ladybird trust?
So talking about a ladybird trust, it's I think it's a mix. You're mixing some things. So typically, you could do planning with what we call ladybird deed. So what a ladybird deed does, it provides that the founders or the owners retain all rights to the property, including interest. They can sell the property, they can mortgage the property, but on the death of if it's a joint ownership by husband and wife, upon the death of the survivor, it will transfer to children. That is a way that you could transfer the property. It has some advantages. One, it avoids probate. Secondly, it automatically will pass down to children. If the remainder beneficiary within that ladybird deed are children, sometimes people will name their trust. So it is a way to transfer property and avoid probate, but to maintain joint ownership among husband and wife if that's the intent. And the other thing and benefit of that is that a transfer from a parent down to a child is exempt from uncapping, as I had briefly mentioned. So again, you don't have the concern for uncapping if you handle it that way.
So to follow up, she wanted to add it. She meant to say a ladybird deed.
Yeah. Okay.
Okay.
Yeah. So that's a ladybird deed. That's correct. Yes.
Next question. We have 4 cottages under one trust. Our mom, who created the trust, has passed away. How soon do we, my sister and I, need to create a new trust? And does this mean automatic reassessment?
So there are specific exemptions, and there's potentially a uncapping depending on how you handle that transfer. So I do have some concern if it goes from trust to trust. So unfortunately, in this current under current law and the way we plan, we may do multiple deeds. So if you have 4 deeds in your mother's trust, or 4 cottages in your mother's trust, what you may do is transfer it out to the 2 of you, you and your sister, and then you develop a trust and transfer it from you into the trust, however that's going to look like, or whatever it's going to look like, however you're going to divide it among ownership. So there is a way to make the transfers and to plan without triggering an uncapping. But again, I think you need to look at it and plan for that, because you could have an inadvertent uncapping if you just transfer it from a trust to the new trust, or if there's multiple trusts to the new trusts.
Okay. Yeah. Thank you, Mark. What are the rough costs to develop an LLC or a trust? Does it cost about the same for either?
Yeah, from my standpoint and the way I develop these plans, it is the same cost. There's not a difference in cost. Other than there's a little bit more formation costs with regard to LLC. You have some filing fees that you file with the state, filing and establishing the articles of organization. But with regard to the actual planning document, it's a similar cost. And when I say a little bit more, maybe a couple $100 additional with an LLC compared to a trust. So the normal in planning, the normal cost, I'll estimate between probably $4,000 and $6,000 to develop a plan, whether it's an LLC or a trust. The big significant issue is how long it takes to finalize that either trust or operating agreement that you use with the LLC. I have some families that go through 10 drafts, and that would tend to increase the cost compared to if you can kind of finalize it within one or two versions of the trust agreement or the operating agreement.
So following up on a question, so we can, in addition to the recording of the presentation, we can also email a PDF of the slides. If Mark, that's okay, I can include that in the email to everyone. Following up on that question, Mark, here's another one. Which is preferable, an LLC or trust?
So that's a great question. So there's various factors that will determine what is best. So I will say with regard to my clients with Michigan property, probably 75 to 80% will do a trust because of the concern for uncapping. So remember, with regard to a trust, you can transfer a beneficial interest down at least 2 generations without an uncapping. With an LLC, you can only transfer if you transfer more than 50%, so up to 51%, and these are cumulative transfers, an uncapping will occur. So if you have 100% in generation 1 and it goes down to generation 2, that 100% eventually will be transferred down to generation 2, and you will have an uncapping event in that the transfer to that second generation. Now, note that this the treatment under the trust for uncapping to allow it to go down 2 generations without an uncapping event, it has to be residential property. And the statute defines residential property as property that is not rented out more than 14 days. So if you rent your cottage, that favorable trust treatment would not apply. And the other thing I would have you look at, I kind of like the LLC structure, and I like the LLC for it is a limited liability structure. And so that has that benefit. And I think the structure itself with managers and members lends itself well to this type of planning. But in either case, you would ensure, so with the trust, the fact that it doesn't have limited liability, it's not a limited liability entity, you're going to have insurance in either case, and you can insure for potential risk and those kinds of things. But note that if you rent the property, then it probably doesn't matter whether you use a trust or LLC. So many clients of mine, if they want to rent it, will use an LLC for that added kind of limited liability protection. So it depends on your circumstance, but those are the primary issues. Do you rent the property? What does the uncapping look like? Again, if you take a look at your property tax assessment statements, look at what the assessed value is, look at what the taxable value is, look at the gap, and you can calculate what an uncapping might look like as far as increase in property taxes. So you have to look at various factors to determine which one you want to use. But I will say probably, again, 75 to 80% of my Michigan clients use a trust because of this concern for about uncapping.
Following up on that question, and then I'll get to Sandy. So who pays the taxes and files a LLC?
So the LLC, it's a entity, and you would uh, so you file what they call articles of organization, a single page with the state of Michigan. There's a filing fee, not significant. I think it's $50 to file the articles. So, in setting this up and preparing the cottage plan, if I did it or I was assisting you, we would file it. We'd make sure the filing gets done and that kind of thing. With regard to LLC or trust, if you're talking about income taxes, both entities are kind of a pass-through entity. And you wouldn't have taxes if you aren't generating income. If you're renting it and generating income, then the taxes would, in an LLC setting, the taxes would be paid by the members. It's a pass-through entity, so the members would pay the income taxes if there are some. With regard to a trust, either the trust or the beneficiaries would pay taxes. I'm assuming, I don't know if you're talking income tax, obviously property taxes would be paid by whatever entity owns it. It'd be a cost to the limited liability company and its members probably, or the trust and its beneficiaries.
Income tax.
Yeah. Okay.
All right. Does it make a difference that one owner has a trust already while the other two don't? The trust owner lives in California, if that helps.
So based on the question, it sounds like there's three owners, and if you own it as tenants in common, uh, and if the three of you are going to develop a plan that's a plan altogether, again, it wouldn't make any difference if if yours going to be transfers, we transfer in a way that we wouldn't have an uncapping event. But it doesn't really make any difference. I'm assuming the one with the trust will transfer down to their children. No uncapping occurs. The two without the trust, again, they can transfer down to their children without an uncapping. If you're going to develop an overall combined plan among the three of you, it should make a difference. We would ultimately get the cottage into that LLC or into the trust as part of the plan.
Following up, the trust owner has no children.
Okay. Yeah. So that might create some particular issues depending upon how the transfer is going to be made or what you're going to do. Because interestingly enough, and it doesn't make a lot of sense, but under the current uncapping statute, transfers to nieces and nephews are not exempt from uncapping. It's down the kind of down the line, but transfers to brothers and sisters are, but not nieces and nephews. I don't know why they drafted that way, why it's left out. So you may want to look at if the person that has it in trust, I don't know how they're going to dispose of it, but that could be an issue. Where it goes upon the death of the person who has the property in trust. And if it goes to siblings, no uncapping. If it drops down to nieces and nephews, there's the potential risk of uncapping.
Thank you, Mark. Is there a legal time frame that we have to move ownership from one trust to another after the death of the original owner, or is there just a recommended time frame?
Yeah, so I don't think there's a legal time frame. Normally the expectation or anticipation would be that you do it in the normal course of administration of the trust. Having said that, I've run across clients who have held it in trust because they've been either concerned about uncapping or other things. That I have one client in particular that I think they've had it in trust for probably 10 years. Now, there's been no negative ramifications of that yet, but if the assessor were to explore that or see that or investigate that, there might be some issues with regard to either uncapping just because they're holding it in this trust. So I think you need to be careful, but usually normally in the normal course of administration, but there are no legal rules for that.
More of possible financial ramifications could happen?
Potentially, yes.
Okay, thank you. If we inherited if we inherited in a trust, do we own it? As in, do we have to claim it on our FAFSA?
Yeah, so that's a good question. I don't know about FAFSA. In all honesty, I haven't dealt with that. It's something that could be looked at, but I think the fact, uh, if you're the beneficiary in a trust, if it's yours, you probably need to claim it. If it's your children's, I don't know. It's something I'd have to look at. That's something I don't know off the top of my head.
Wonderful. All right, so it looks like we are all set with questions. Once again, if you do have any additional ones, you can reach out to myself or Mark, and I'll relay all of that information over to Mark. Like again, in the next couple of days, be on the lookout from an email from me. I'll include a link to this full webinar, also with the slides that Mark presented with. And besides that, I hope that everyone has a wonderful rest of the evening and a great start to your week tomorrow.
And thank you again for the opportunity to present. And my contact information is on the slides, and I think Eric's can get that to you if you'd like to have any other questions or would like discuss anything more specific. But yeah, enjoy this beautiful weather. It gets you ready for the cottage season, and I hope you all have a great summer. So thank you very much.
Okay.